So you fall at work and you severely injure your left ankle and you need immediate extensive surgery on your ankle. What you don't realize maybe right away is that you also, in the fall that you had at work, severely injured your lower back. Turns out you popped at least a couple of discs down there, and it's pretty bad. But because of the pain medicine they have you on in the hospital, and as you're recuperating from your surgery, because you're mostly horizontal for a while with that ankle, you really don't notice too much about the back. Maybe you know that you hurt your back, and maybe you told them in the emergency room. The orthopedic doctor they're treating now is really treating you for your ankle, so you don't really say anything to him. Meanwhile, the workers' comp insurance carrier accepts the claim, but on the award agreement in Virginia or in North Carolina, we call it the Form 60, they only put the ankle. You don't have any ongoing complaints about the back yet, okay? So time goes by, and you're recuperating from the ankle injury, and you start to notice, though, that your back injury is, it's hurting you more and more as time goes on, and it's getting bad. And you seek treatment and even pick a doctor for your own on your back injury. And now, here's the critical part. You try and get workers' comp to pay for treatment, but they say no, they deny it. And then, you're not sure why, but you need treatment, so you just say, okay, well, I'll just go through my health insurance for now, and we'll just deal with it that way. And you move ahead with your back treatment through your private health insurance. Maybe you even get an MRI, which is a very sophisticated way to look at your back inside, and they see the disc problem, but they want to try some conservative measures to try to treat your back. Now, your job won't take you back on light duty, so you end up getting another job somewhere else for actually more money. So they're not paying you any more workers' comp because you went off and got another job, paying more money, and so workers, the weekly checks, they're done. Another year goes by with conservative treatment, injections, things like this in your back, physical therapy, nothing works. I mean, maybe you've got some severe issues going on down your leg, you've got some sciatica, it's getting worse to the point where you're not even sure you're going to be able to work anymore. The doctor that you got through your private health insurance has recommended surgery on the back. Your previous job had health insurance, but this job, either you're not qualified yet or whatever, they don't have health insurance at this new job, even though it pays pretty well. So you go back to the workers' comp carrier and say, okay, I need to get this covered. I hurt this I hurt my back in the workers' comp injury, and they say no. Why? Because they say that the statute of limitations has run on that case and on that injury, and that therefore, because you never made a claim for the back injury, you got no way to pay for it now. So you don't understand what happened. How can the workers' comp insurance company do that to you? After all, you did tell the ER doctor about your back injury, but now you're stuck. Hi, I'm Joe Miller, workers' compensation attorney in Virginia, North Carolina, and today is what we're going to talk about, which is the statute of limitations on workers' compensation claims. I've talked about this a little bit in some other videos, but I want to get into it in this context a little bit more. So what is, first of all, a statute of limitations? In Virginia, North Carolina, the general rule is that you must file a claim. What that means is a piece of paper that's basically saying, I have a claim for workers' comp, and these are the injuries that I have, and this is how it happened, okay? You got to file that thing with the appropriate commission. Virginia, that's the Virginia Workers' Comp Commission. North Carolina, it's the Industrial Commission. Or you have to be awarded benefits by agreement or otherwise within 2 years of the accident. Basically, in Virginia, there's something called an award, and the award entitles you to benefits. It's basically the proclamation of the Virginia Workers' Compensation Commission says, yes, the workers' comp carrier and the employer, they owe you this money, they must pay you this money every week, and you have lifetime medical benefits for whatever body part they're accepting as the claim. In North Carolina, there's a similar thing. They don't usually call it an award, they call it an accepted claim, and that's usually done in North Carolina through something called a Form 60. Even if you have an award or you got an accepted claim, you can run into some problems if that award does not mention the specific problem that you're having now. For instance, in this case, right, you originally hurt your back, but you never claimed it and they never accepted it. Even if you had filed it, all they accepted was the ankle. So you're going on with your life, you're not getting paid any money, but you're going on with your life and you think that they're going to somehow pay for it, but now the time has run out. Now I'm going to tell you, there are, in Virginia specifically, sometimes some exceptions. There's some savings provisions that can, in some circumstances, extend the statute of limitations. If this gentleman in this example, for instance, had stayed out of work and was unable to return to the job, and they couldn't accommodate him, and they kept paying him that weekly check, that would extend the statute of limitations for every week that they continue to pay him that check. But that whole thing about these extensions, that's a little outside the scope of this video. My main purpose, as always in these videos, is really so when you come to us, if you have a case, I don't want you in a situation where we have to tell you there's nothing we can do for you because that ship has sailed, okay? We don't want to do that. We want to be able to help you. In this particular circumstance, this guy had this back injury, he never claimed it, or if he did claim it, they didn't agree to it. You're already beyond the 2-year time limitations. He elected to use his own health insurance. They didn't pay for any treatment on an ongoing basis for the back. They, meaning the insurance carrier, his weekly comp check stopped a long time ago, and then more than 2 years went by. And so by using his private health insurance, by trying to get under workers' comp early on, and not getting him any more comp checks for 2 years, basically he took himself out of the statute of limitations and out of any potential exceptions to those statute of limitations. So what should our friend here have done? Proper approach in Virginia, assuming that he really did hurt his back in the accident, would be before the 2 years are up, for him or his attorney to file a claim form. The same thing you file at the beginning. You're going to fill out the top just like you would fill at the beginning of the claim, but at the bottom you're going to put a change in condition, and then you're going to put treatment for lumbar spine, something to that effect. And then your attorney will go ahead and then attach the records that support, even though it was with a non-workers' comp doctor, you would attach the emergency room records where you mention your back being hurt and all the other records that you have supporting that. And the earlier you do that, the better. I mean, if you wait, till now the doctor is ready to, almost ready to recommend surgery, and even if it's just before the end of the 2 years, you got a problem because the doctor that you treated with under your private health insurance is not authorized by any workers' comp carrier. So, maybe the commission will look at it, maybe they're not going to look at it so favorably. So it's very important that you try to nip this in the bud fairly early. What I try to do is there's always a balance in these cases. Some people will say, I want all my injuries included right away. Well, if you try to do that from the start, sometimes it creates a problem because the insurance companies kind of balks at it and says, well, we're not going to cover anything then. Then you're stuck because you don't even have your weekly checks, and you need your weekly checks to live. If I'm representing you, they'll say, we're accepting the ankle. Say, okay, fine. We'll let them go ahead and accept the ankle. We'll get you under an award. But once that thing is in place, and they can't change it, the 30 days go by and it's finalized, then we start looking at trying to get your back treatment covered once it becomes a problem, okay? But you don't want to wait till it's almost the end of the 2 years to do that because it's going to be much harder. Now, in North Carolina, you probably just, your attorney would really contact the other side, their attorney or the adjuster, and say, look, you guys won't agree to this back thing or not. And if not, you want to go ahead and get your records together and make a motion to have it included. And hopefully you complained in the emergency room about your back, even though it was not the main thing that you treated for early on to get that thing covered. In our scenario, once you file that paper, okay, even if you pass the 2 year mark after you file it, okay, once you file that paper before the 2 years are up, you have protected your rights, okay? You've got that 2 year window that you've got to file. If you've got some injury that you think you hurt originally in the accident, you've got to file that thing. If you don't take action to protect your rights on this other injury within the 2 year window, and you're saying you hurt your back at the time of the accident, you're going to end up in a world of hurt because it's going to be too late to claim it later. If you have a serious medical condition, okay, that is related to the accident where you hurt it originally and it somehow got left out of your formal lifetime medical award, or it somehow got left out of the top portion of the form on the Form 60, the best practice is to make a move, either via a claim form or some other motion or something in North Carolina, to get it covered within the 2 years of the accident. Otherwise, you could be completely barred from ever obtaining any coverage for that injury. What if another injury happens after that, due to the original work accident? In Virginia, we call that a compensable consequence. That whole concept deserves its own video, and maybe we'll do that at some point. But let's just give it a quick example. And I've had this, by the way, before. Had a lot of these before. Let's say you hurt your back pretty bad, and you got your lifetime medical award for your lumbar spine. The back injury is causing you very well documented right leg weakness, okay? So much so that oftentimes your right leg will give way because the sciatica and whatever, the weakness in your leg is so bad that your right leg is giving way because, and this is all because of your back injury. So now it's more than 2 years after the accident, right? You're still getting your checks and everything, but it's more than 2 years. Suddenly you have one of those giving way episodes, boom, you fall down, your right leg gives way, it causes you to fall and severely injure your left ankle, okay? Which now needs surgery, okay? Now, the only reason you fell, and your doctors have to support this, by the way, the reason you fell is because of the leg weakness. That's well documented, okay, on the right leg. And so what that means is that the ankle injury is a compensable consequence of the back injury. Okay? In other words, it only happened because you had a back injury that you have been awarded. Okay? So in this particular case, we did have to go to a short hearing, but we got it covered. It wasn't a problem. As to the 2-year statute of limitations, doesn't apply. Why doesn't it apply? Because it's a new injury, really. Even though it's connected to the original injury, it happened later. So you would have 2 years from that date to go ahead and file that claim form for what's called a compensable consequence injury. Let's discuss, and I've discussed this before, a final scenario for statutes of limitations is I like to call, the nightmare scenario, because this is about as bad as it gets. And let me make this absolutely clear, because I see this all the time with clients coming, potential clients calling our firm and said, well, my employer said that they were going to take care of it. My employer said they went ahead and filed the claim. And make sure we're absolutely clear. Nobody can enforce your rights except you or your own attorney. Your employer can't do it. The insurance company cannot do it. Okay, no matter what they tell you and how they say they're going to take care of you, do not listen to that. Okay, because that is a surefire way to lose everything. Okay, and unfortunately, that's what happened to this unfortunate gentleman. If he'd only known his rights, all he would have had to do was take a few easy steps, or we would have taken it for him. So he had been injured 10 years before he called our office. Tragically, he completely lost one of his hands. He never filed a thing with the commission. Never filed a thing. There was no award ever entered. But the carrier, the insurance company, voluntarily paid for all the treatment initially for his hand, and had him come back to work on modified duty. And he, had not treated for that amputated hand in many years, even though he was entitled to all kind of prosthetics and all kind of things that could have helped him lead a better life. After 10 years after the injury, they fired him. They said, we can't deal with this one-handed guy anymore. They just let him go. Because in Virginia, we're an at-will state. They can fire you for just about any reason. There really was nothing we could do. All the statutes of limitations had expired long ago. He was never paid any permanent partial impairment money for the hand. He would have been entitled to quite a bit of money for the loss of his hand, just that part, even if he went back to work. He never filed anything, so he didn't get an award, got no lifetime medical award. So all the prosthetics, the value of the ongoing prosthetics for years to come, for the rest of his life really, anything like that, all gone, because he never got a lifetime medical award for the amputated hand. In Virginia, if it can be shown that the insurance company, the employer, never filed what's called a first report of injury, that means the statute of limitations never started running. But that is very rare that happens. I hope you please learn from this nightmare situation and make sure to know, first of all, that only you can protect your rights, or your attorney. Your employer can't do it. The insurance company can't do it. You've got to take action to protect your rights under Virginia and North Carolina workers' comp law. Please make sure that you filed your claim on the Form Virginia or Form 18 of North Carolina, and all claimed injuries have been claimed. Or if you have an award or a Form 60, every single injury that you're claiming that's serious is on those forms, okay? They're on those forms and they've been accepted as part of your claim. If you don't have that, you're going to have to file something to claim them if you want treatment for it or you want to be compensated for those injuries in any way. If it's a body part that can be rated, which is something we'll get into, we have other videos that I have actually on that, on what's called permanent partial impairment, where you can get a rating. You want to make sure you claim that rating. Even if you haven't gotten a rating yet, you want to make sure you claim it within 3 years of the accident. I strongly encourage you to see my video on permanent partial impairment ratings. You just want to make sure your rights are protected. If you have any questions about Virginia workers' comp, North Carolina workers' comp, you're not sure if your rights are protected, you or a loved one, please don't hesitate to give us a call. We'll be happy to help you. Have a blessed day. Joe Miller out.